Okay, hello everybody. Hi. Welcome in. Hello. Oh, what a day it has been, right? For everyone. Well, welcome in everybody. It is Wednesday. Thanks, Wes. I tell you what, we got into a bit of a fight, my nails and me. So I have this set on this hand, and then I have a different set over here. Although this one is like wanting to be over there. So yeah, there have been words exchanged. It's a bit of a fight. So, yeah, but we're gonna make it through. We're gonna make it through. Now, today, of course, is Constitution Day, everybody. I'm sure you all knew that. It's okay if you didn't know, it's fine. So, here, what I've got that's fun for us is to take a look at some of these founding documents. Oh, thank you very much. So, a lot of people don't know the order of the documents or even what really they are. I'm sure all my peeps in here know, of course, but it's always fun to do a little refresher here, just for fun. So, I thought I would go through some of our founding documents, but really spend some time on the Bill of Rights and the amendments. I did, I think 2 days ago, I went through the articles with a lot of details, and those will be posted up over on my Tube of You channel very soon. So, of course, we've got to make it through the amendments tonight. But I thought, well, let's kind of take a peek at some of the other documents that are really important. Now, I know there are multiple lives going on right now, everyone, but this is educational, low-key, non-debate, no hatred kind of a live here, just to tip our hats at the Constitution and maybe learn something new. So that's really the goal for tonight. And I will also take this time to remind everybody that once a year on Halloween, I do go live to read through the docket and evidence of the Salem witch trials. So we do a different alleged witch each year. So this will be our third year doing it. So we have a lot of fun, but that is on October 31st. So we kind of do some little specialty lives here. This is for Constitution Day. We also do one for Thanksgiving where I go through the first speech George Washington gave about Thanksgiving, along with the Mayflower Compact. I go over that as well. So those are kind of my three kind of little special ones that we do to just learn, more about, yes, exactly, Steffi, more about our history, how things were written in the documents and such. So it's pretty neat that it's all wonderfully available for us online. Thank goodness. Hello, Olga. Hello. So I want to start with the Declaration of Independence here. Oh, I got a little sticky note on here. This is where I believe I put a sticky note on where they are referring to our indigenous people as savages. That's probably what that's for, but we'll just move it. We'll move it over here. Oh, that's so sweet. So here's our first document, everyone. Again, I really want to kind of walk you through the founding documents, and then we will just deep dive into the Bill of Rights and the rest of the amendments. So this is our Declaration of Independence here, signed. Well, it was signed on multiple different days. John Adams was like, it's July 3rd. So this was always kind of like, that's weird. But July 4th, Philadelphia, and it was a scorcher. There was a lot of bad stuff going on as far as like health and stuff because of the time. So it was a lot. Yeah, I saw that. Jimmy Kimmel. Yes, we're going to have to see how that shakes out, though. Sometimes things take a little bit of time to shake out to see what the final situation is going to be. So this, again, unanimous Declaration of Independence here for the 13 United States of America. This is the first time they were called this. This was written by Thomas Jefferson. It had multiple other pieces actually included. There's 4 sections here. The first one saying, that famous bit like, well, in the course of human events, right, blah, blah, we need a new government. And then they list 27 complaints. All right, so 27 complaints against the king. I have been posting those just, one at a time over on my page with the actual language, and I will be picking that up again very soon, but there's 27 complaints that they have against the king. And then down here, we have kind of this closing piece. We, therefore, the representatives of the United States, here, and then the signatures down here as well. All right, so that's our Declaration of Independence. Usually, anytime you get a constitution, even if it's a little one like this, they will typically include the Declaration of Independence in there because it's, it's kind of a big deal, right? So let me just see if I've gotten here. Oh, here it is. In this one, see, it's all the way back in here. But there's usually a declaration included. Declaration of Independence, not a law. Some people mistake it as a law, and you can certainly cite the beautiful language in the Declaration of Independence, but this is not a legally binding document. It was a letter sent to King George, and I believe this one was the third one. They had sent letters previously saying, hey, we got some problems over here. Can you get stuff sorted out? He didn't respond. He had other things apparently. Hello, Willie B. Hello, So Unique, Dania. So he hadn't responded. And so that was actually put in here too, where one of the complaints was, well, we tried to talk to you, but you wouldn't talk to us. So there's a lot of complaints here. So this was, again, the Declaration of Independence. Now, one of the problems after the Declaration of Independence, there were multiple. One of the biggest problems, though, was that they didn't have a structure for their government. And that's kind of a big deal because they're like, UK, we're out and we're going to govern ourselves. But we didn't have anything set into place for government. So the first thing that we did here by the Continental Congress, and this was in 1777. So I'm going to walk you down the road here, everyone. 1776. For the Declaration, 1777, we have the Articles of Confederation. So the reason they're called Articles of Confederation is because that's kind of what a lot of the indigenous tribes had been using. I think the Iroquois had a huge influence on Benjamin Franklin, who had set out a set of Articles of Confederation that were rejected. He was 20 years too soon. But these were kind of thrown together, so not that great. Hi, Kaya. So I want to read just a little bit here of the Articles of Confederation to show you why we have a constitution. If these had worked, we would not have a constitution. We would still have the Articles of Confederation, but they didn't work. There were so many problems that the Constitution was needed, and that's why we get into what everyone refers to as the Federalist Papers and the Anti-Federalist Papers, because they're kind of like debating back and forth how to design the government, which is the key, right, to the Constitution. So let me give you just a couple of quick paragraphs here out of the Articles of Confederation to give you some idea of what they're talking about. I have no problem calling them the Articles of Confederation because that's what they are. But for some reason, this little book that I have here, and I suppose there's several names, but this little book I have calls them like the Articles of Association. And so I think there were multiple different titles that were used, but I have always used Articles of Confederation. I see no problem with that at all. So let's read a bit here. The First Continental Congress, all the way back here, when we're dealing with the king. But what I want to get into is where we have the actual pieces that they're trying to do. So let me set out here for you some of the parts of the original structure of our government. All right, so Articles of Confederation here, all right? That from and after the first day of December next, we will not import into British America from Great Britain or Ireland any good wares or merchandises whatsoever, or from any other place any such goods, wares, or merchandises as shall have been exported from Great Britain or Ireland, nor will we after that day import any East India tea from any part of the world, nor any molasses, syrups, panels, I don't know what that is, I'm not saying that right, coffee, or pimento from the British plantations or from Dominica, nor wines from Madeira or the Western Islands, nor foreign indigo. So let me pause here. This, of course, was before the Civil War, so of course there was still slavery in the country. So we keep that in mind here as we're looking through how this is set up. And also as a friendly reminder that John Hancock was a huge smuggler. And so one of the things that he smuggled a lot of was wine. And that was one thing that Benjamin Franklin was extremely excited about. Right. Exactly. All right, so number 2. That we will neither import nor purchase any slave imported after the first day of December next, after which time we will wholly discontinue the slave trade and will neither be concerned in it ourselves. Now, we do know that that did not actually happen, but that was set out here. Nor will we hire our vessels nor sell our commodities or manufactures to those who are concerned in it. So it was set out. It was a piece in here. And again, as you'll see through all of our founding documents, slavery and our indigenous peoples are mentioned because it's such a huge part of our history here. So you can, if people don't want to teach it, that's up to them, but there's no way getting around. It's the history's history. Number 3, as a non-consumption agreement strictly adhered to will be an effectual security for the observation of the non-importation, we, as above, solemnly agree and associate that from this day we will not purchase or use any tea imported on account of the East India Company, or any on which a duty hath been or shall be paid. So this is kind of reminding me of tariffs. Anyone else? Is this sounding like tariffs a little bit here? And from and after the first day of March next, we will not purchase or use any East India tea whatsoever, nor shall any person for or under us purchase or use any of those goods, wares, or merchandises. We have agreed not to import, which we shall know or have cause to suspect were imported under the rules and directions of the 10th article hereafter mentioned. All right, so let's skip forward here to, I've got a couple more that are like my personal favorites here. So we're not trying to injure Great Britain here. Over here, we've got a non-importation agreement. Owners of vessels will give positive orders, utmost endeavors to improve the breed of sheep. That's important, and increase their number to the greatest extent. And to that end, we shall unalive them as sparingly as may be, especially those of most profitable kind. So we've got some sheep for sure. Where can I get one of these blue books? Oh, this one. Where did I get this one? If I see a Constitution, I pick it up. So, let me see here. Ooh, let me see where I got it. Does it say? Oh, I think I got this one at Five Below. I don't know. This is Five Below here, everybody. Less than $5. Can you believe it? So, there you have it. The print it's really nice. I know. My other blue, this is what I get confused with too. This one I use all the time as well. And this is on the Jungle Purchase Place. All right, so sheep, right. Fast forwarding here again, one of the big ones again, they're going through trading. That was the big deal then. Committee on Correspondence from the colonies. They're like, let's just have one person kind of get it sorted out. Oh, no, you couldn't find it. Oh, I'm bummed. I'm bummed about that. Resolve trade and commerce issues, and then we're swearing in here, blah, 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 blah. So, all right, let me pull out the piece here. Fast forwarding it again. Yikes. Let's look here to the style of the Confederacy, the United States of America, right? Each state retains its sovereignty, right? Perpetuate. Oh, okay. This is one of my favorite pieces right here. Let's look at this article. So, the said states hereby severally enter into a firm league of friendship. So, whenever we go back and try to figure out federalism, right, which is kind of a big whoop-de-doo-dah, the only real guidance that we had was, well, we're going to have a firm league of friendship with the other states for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them or any of them on account of religion, sovereignty, trade, or any other pretense whatsoever. So there's our League of Friendship. Oh, no. Oh, yeah. I mean, the Constitution's out there everywhere. It's all over the place, and it doesn't have to be fancy, or it can be extremely fancy. All right, so skimming forward here to my next piece. That's my favorite part. All right, so again, right, we're in the Articles of Confederation. Each state shall maintain its own delegates in a meeting of the states, and while they act as members of the committee of the states in determining questions in the United States in Congress assembled, each state shall have one vote. So this is, again, the foundation for the problem with the Articles of Confederation. So we had 13 states. Each one had a vote. I mean, right? Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress. And the members of Congress shall be protected in their persons from arrests and imprisonments during the time of their going to and from and attendance on Congress, except for treason, felony, or breach of the peace. So this is our very first piece here of what Congress eventually becomes. And the speech and debate clause is in Article 1 of the Constitution as well. Okay, Article 6, no state without consent of the United States in Congress assembled shall send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States or any of them except any present emolument. So the emolument clause that's in our Constitution was also in the Articles of Confederation because they thought it was really important. So this was really the only power, true power of the Articles of Confederation was this kind of a treaty language or dealing with the foreign country situation. All right, that was really the only power set in the articles here. So, you know, that had to be changed quite a bit. Back to the sheep. All right, there's one more piece in here that I have to, let me see here. All right. So this is if we need to have a war. Taxes are optional. Remember that. Sole exclusive right here. No. Congress assembled. Right. Okay, I'm skimming here. All controversies concerning the private right of soil claimed under different grants or two or more states whose jurisdiction as they may respect such lands and the states which passed such grants are adjusted, the said grants of either of them being at the same time claimed, let's fast forward. Bloop, 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 bloop. Here, disputes respecting territorial jurisdiction between different states. So here we have any of the land fighting that was going on here. All right, and that one establishes you can make coins, which is fine. And then here we're establishing committees. That's fine too. All right, seriously, I gotta get to my favorite part here. Okay. The committee of the states, or any 9 of them, shall be authorized to execute in the recess of Congress such of the power of Congress as the United States in Congress assembled by the consent of the 9 states shall from time to time think expedient to vest them with, provided that no power be delegated to the said committee, for the exercise of which by the Articles of Confederation the voice of the 9 states in Congress of the United States assembled is requisite. So this is where they're basically saying the states have the same power as Congress. So there's really no separation between the federal government and the states government. And if they're in recess, then the states, act as their own government without going through Congress. And that's one of the reasons why Congress wasn't in session for like 2 years. They're like, why do we even have to deal with this? So that was a big problem. And then this one, just for funsies, just for fun. Article 11, Canada acceding to this confederation and joining in the measures of the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by the 9 states. So Canada wasn't involved. Canada's like, we got stuff going on up here. We've got our own wars stuff. So, but they wanted Canada to join us. And Canada's like, yeah, we're not going to do that. So they basically just saved space for Canada if they did decide to come in and join. I always like to point out this piece about Canada because, it was a player. Canada had a lot of benefit, had a lot of positive things that the states wanted, and that is recognized even in here. All right. So that is, again, fast forwarding through the Articles of Confederation. One last piece here that I think it's important to note. It has pleased the great governor of the world to incline the hearts of the legislatures we respectfully represent in Congress to approve of and to authorize us to ratify the said Articles of Confederation and Perpetual Union. Like, all right, fine. And then up here, again, it's just signed out, and then the other people who signed it, and they didn't all sign it happily. It took some arm bending, and it was rubbish. All right, so there you go. Would read this and laugh now. I know, yeah. Canada's like, see you later. They didn't want to have to deal with the mess. I don't blame them. They had a lot of stuff going on with the French, though. Honestly, I'm not here to bash on the French. All right, I've told myself I'm not going to do that, even though, my family is part French and it's part of the French custom, but I'm not going to. All right, moving away from that. But they had a lot of stuff going on. They had a lot of stuff. Definitely valuable, and so that's why they wanted to pull them in. All right, here we go. This is a picture of what you would see in D.C., I think. And it's difficult to read because it's been written with a quill, and we don't know which copy this was. I think there's like 25 copies that were made at the time. Right. You 27%. Oh my gosh, Kay, I knew it with that gorgeous hair. I knew it. They have the slicey thing. They did. Okay, so let me decipher this for you. I'm not going to read through it because I did a couple of days ago. But of course, it starts with We the People. And of course, this was written by James Madison with insight from Jefferson, from Franklin. Everybody had some insight here. But Madison was the one that turned the language into what they needed it to be. All right. So we the people, here's our preamble. And then the first article sets out Congress. Now, the first article has, I believe, 11 sections to it. And then the clauses as well. So I've just kind of shown you here visually where the next sections are. So if you're wondering like, well, where is the Commerce Clause or whatever, Commerce Clause is gonna be right in here. So just to visually give it to you there. So, all right, so we've got 10. I guess it was 10. I thought it was 11. Oh, maybe it is 11. Oh, shoot. That might be 11. I don't know. I don't know. I always question the federal circuits. Do we have 13 circuits or do we have 12? And then do we have 11 in Article 1 or do we have 10? That's all right. That's all right. Next up, Article 2. So this is the setting up the executive branch, right? So we have Section 1 here, Section 2 up here, and then 3 and 4. Oopsies. Hold on a minute. That doesn't look quite right. Where was I? Hold on. We're missing Article 3. That's crazy. We can't be missing Article 3. That's not right at all. All right, just 1 second, everybody. Let me find, there's Article 2 again. Wait, is this Article 3? Hold on. Oh, I found it. Hold on. Don't be worried. All right, it was underneath the mugshot picture. Sorry about that. Ooh, does he have a filter on? He does have a filter. Look at the filter, it's working hard. Oh my gosh, yes, nice. So look at this, pop, Article 3. Oh my gosh, everyone. What's happening in this world right now? We don't know. All right, here we go. Sorry about that. Let's go back. We've got Article 2 here, and then subsection 2, 3, and 4. The federal courts are set out here. Sorry about the jump scare. Sorry. So in Article 3, of course, sets out the jurisdiction of our federal courts and a little bit of the structure of the Supreme Court here, life sentences. Article 4 is down here. That's the state, citizenship, and new states. And then over here, got to following the numbers properly here. Article 2, 3, and 4. All right. And then we've got the amendment process, the debts, the supremacy clause, oaths that are required, and the removal of any kind of religious tests that may be part of it. They didn't even want to deal with that. And then Article 7 is how to ratify this Constitution. All right. So this Constitution was signed then here, and it was just 7 articles. All right. That's it. That's all it was. It was 7 articles. It had no amendments on it. It was just these articles setting out the government. I'm sorry, Madison. I know I really wrecked the order of things. You get Madison out. Hey, what's up? So I'm Madison. Bye. The father of the Constitution, right? Oh, all right. Again, the 7 articles, that's the Constitution. Everything else, the amendments that came later, those were added years later. All right, and I took you through the articles previously, everybody, so let's swap over and take a peek at the Bill of Rights. The Bill of Rights is extremely confusing if you see it. If you actually see, I think I have a magnet. I have a teeny tiny magnet of it. Sorry, side trip, squirrel. And it's very odd because all of the amendments that we have listed, right, in the Bill of Rights are amendments, and yet here they're actually called articles. So the language of the amendment is exactly what we know, but the actual title was as an article. So that gets a little bit messed up because we just dealt with 7 articles, right? Designing the government. Now we're coming in with a Bill of Rights. So we've got 10 here, and they also referred to them as articles. So when you see new amendments added, we've got a total of 27. what you'll see at the very beginning is this introduction as an article rather than saying, okay, now the 15th Amendment, blah, blah, blah. It's the 15th article or Article 15 because that's the structure, the verbiage that was put into place in the very beginning. All right. So again, just to kind of take you through the Bill of Rights, which is just this one sheet here, we have date and location set up here, the conventions. Then they're like, well, we resolve, we're going to blah, blah, blah. And then the articles. So as you can see here, there's actually 12 articles that were proposed. They had originally had an Article 1 and an Article 2. Those were removed. They cut these out. So it was actually the third one, which became our First Amendment. So when you look over here, this is the actual verbiage because those were never actually removed from the document. They were just like, struck. So they're still there. The printing of it is still there of these two pieces that were not accepted. They were not passed for the Bill of Rights. But then when we get to number 3, for our First Amendment, it's still going to say third, fourth, fifth, and sixth. So the number does not match up with the language. And so a lot of people will go look at the Bill of Rights and they're like, this isn't right. This doesn't seem correct. But this is how they set it out. So this first piece was cut out taken right off the top. Let me just double check here what we had here. Let's see. Okay, the very first one here was going into some more details on regulating representatives and such, and numbers. So this was already really taken care of in the first article, and they weren't ready to move it forward yet. The second one, actually, which is really kind of an interesting thing here, the second article is actually our 27th Amendment. I know, weird, right? So here is the second one. The 27th Amendment was proposed September 25th of 1789 and ratified on May 7th of 1992. So it was out there, but not ratified until 1992, and it is now part of our Constitution. So here's the language. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. So it's basically saying, you can't just swap your salaries around all the time. Again, this was proposed September 25th of 1789, ratified May 7th of 1992. All right, so that's the second one here. And then, of course, we have our list of the Bill of Rights. So let me grab a copy that's actually readable, and we can start to go through that. Here we go. I don't know. Those might not be in order. We will see. Oh, article, amendment. Here we go. Nope, that's another article. Okay, so 27. Oh, we got 4. Oh, that's 4 and 5. Sorry, everybody. I have so many constitutions here that, sometimes they get combined with each other. It sounds like forever ago. I know, right? Right? Yeah, it's a big gap, Monique. I know. So what took so long? Well, that's a great question. And I would say that there was actually a group, and this always reminds me that if you want something and you get a whole bunch of people together with that same goal, it can happen. So this piece that was cut from the original, the people in the late 80s were like, dude, let's get it back into the Constitution because, salaries, that's important. So they did what they needed to do campaigning wise, and they put it through, and it went through Congress. Can the Supreme Court strike down an amendment as unconditional? No, no. The Supreme Court, and that's a really good question, the Supreme Court will interpret the amendment, but to make the determination as to whether or not the amendment's constitutional is outside of the purview of the court, because whatever amendments get written are written by Congress. So the process is all through Congress according to the Constitution. So that's their job, or the constitutional conventions. So the courts can take a look at whether or not it's being interpreted correctly, but cannot remove it. That's outside of their, unconstitutional. Yep. That's outside of their jurisdiction. They cannot do that. They can hear cases and controversies, but we have a corrupt SCOTUS. Yeah, well, you're not wrong. Hold on a minute. I'm like, ethics, what can I say? You're not wrong. We got some problems with this Supreme Court, but honestly, we've had problems with the Supreme Court for a long time. Doesn't mean it's okay. But you can see in the past where some have really gone outside the bounds of what was allowable, and they get brought back in. So, I think about it that way. And I also think about just the very basic structure that's written in the articles, put the checks into place. So that's where I'm looking. I misspelled. No, it's fine. Oh, don't worry about it. We knew what you were saying, Tyrion. We knew what you're saying. Rotten Congress and SCOTUS. Well, the thing too, is that Congress is very, very close. In fact, I think this is the closest Congress we've ever had. Fact check me on that, where we're just a couple of votes one way or the other. So truly, it is the closest call. The Senate's still, again, the VP's got to come in and do stuff as well. So it's, hard to get anything done. It's closer than what it was when Biden was in office. And as we saw, not much was able to really get done there as well. Right. It's like a tug of war, and everyone's equal at the moment, really. I mean, there's a bit more tug on the conservative side than on the liberal side, if you want to use those terms, or right or left. But it's really in the middle right now. So this next election will really make or break, U.S. history. So let's go ahead and dive on in, everyone. Right. So here we go. I've not highlighted anything here because I want to keep it open so we can just have kind of an open discussion about our amendments. Again, there's 27. So there is an actual preamble to the Bill of Rights. Who knew that? Nobody. Nobody knew that there's a little preamble here. But there is a little one set out. So the conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. And as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. So that's the preamble piece here. And then next is resolved. Again, I'm just reading the actual language in a format that makes it readable. Hello, Robert. There's more than two. Yeah, I know, right? That's crazy. Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, or all or any of which articles, when ratified by 3/4 of said legislatures, to be valid to all intents and purposes as part of the said Constitution. All right. So again, you remember we have 7 articles designing the government. And then they came back with 12 more articles to add to the Constitution. They added them as amendments, so they're not part of the original Constitution. All right. And then the last piece here, articles in addition to the amendment of the Constitution of the United States proposed by Congress, ratified by the legislatures of the several states pursuant to the fifth article of the original Constitution. Of course, Article 5 sets out how to go about adding an amendment. All right, so let's dive in, everybody. Let's just dive right in here to the amendments. Now, we have the Bill of Rights, but after the Bill of Rights, every single amendment had its own separate resolution that went through Congress. So it's like this is the only one that lists out a whole bunch. Everything else is individually done because they were all done on different days at different times. Here we go. Amendment number 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So I would have to say the First Amendment is probably the most famous worldwide of all of the amendments, because there are 5 different rights in here. I'm going to call them rights, all right? We'll just call them rights. It's easier that way. There's 5, and like the most important ones at the time, right? So we've got religion, which is 2 parts. You can't establish a national religion. You can't hinder the free exercise of religion. So, you know, this is the one where the Supreme Court has come in and said, if you want to, you know, have cobras in your basket as part of your religion, that's fine. But just, you know, be safe about it. Make sure you're zoned properly for it. How do we petition for redress? Well, we go to court, right? Right? That's when we're after the government, we're going to sue them. And that's, you know, 350 cases right now in my closet. So there's lots of different ways to redress, but the one that comes to mind most frequently is having access to the courts to tell the courts there's something wrong with the government. So the religion has 2 pieces. Also, you can't have multiple wives. Very famous case as well because of tax purposes. So you can't have, or spouses, I guess it doesn't have to be wives. Tax purposes, the Supreme Court's like, sorry. So there are exceptions. There's exceptions to every single amendment. No right is absolute. It's just not. Freedom of speech, there's a lot of layers to that. Or of the press, again, a lot of layers to that. Or the right of the people, again, to peaceably assemble. So time, place, and manner can be set for the peaceably peace. And then the right to assemble is also very important. So that has to do with, and in fact, this is one of the big pieces that is dinging the Citizens United situation. If for those of you familiar with that, the right to assemble with other people and whether that's confidential or not confidential. So this assemble right has really been discussed quite a bit. Government versus private free speech is different. Oh, right. Okay. Well, all right. I'm gonna circle around, VC, and let me know if I catch everything here. So, and then petition the government, right? So we can sue for that, or there's various other things in order to ask the government to knock it off. The thing that is so important to remember, and that most people don't, I'm grabbing a highlighter, is that the amendment isn't giving you any rights. So the First Amendment's not being like, here you go, here's 5 rights. No, what they're saying is that Congress cannot make a law, all right, can't make a law that prohibits your religion or abridges your speech or press or the right to assemble. And the petitioning of it. So what does that mean? It means in order to have a First Amendment violation, you have to have the government as one party, all right? So the government, you're suing them. So we have a person. I was going to draw a person, but now I'm feeling uncertain about my drawing skills. We'll just draw a person here. All right, person versus government. All right, so if you have a person versus another person, that is not a First Amendment issue. All right. The issue is if there's been a law created by the government, a local ordinance, some kind of restriction, your state legislature, the federal government has passed a law and it's restricting these 5 rights. All right. That restriction by the government is what is not permitted. So this is where we get into issues of like your neighbor, right? Let's say that you hate your neighbor and you're standing there outside and it's like 2:00 in the morning. You're like, I hate you so much. You're the worst thing ever. You dog barks, blah, 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 blah. It's really, really loud, right? So the person that is your neighbor decides to go to the city council and make it so that, no words can come out of people's mouths after 1 p.m. or after 1 a.m., right? So that would mean what you're doing is illegal and the government's going to come get you and fine you. There's going to be some repercussion. So no, you can't do that. That is some kind of a local ordinance, a law by the government restricting your speech. Now, the government also has an ordinance that is a noise ordinance where you can only go up to a set of certain decibels. Now, you may say, well, the government's restricting my speech. Not so, not so. The government is trying to protect the citizens. They're protecting society by doing this. And so because of that, you need to keep it down to a certain decibel level. All right. So that cannot be pulled from the books because it's a protective piece. The common policing power is how the Supreme Court puts it of the locals. All right. So time, place, and manner also so important. Time, place, manner, right? So we've got a lot of protests going on. I know there've been a lot of really great people out there giving, I'm sorry, my spelling skills are atrocious. But have given people a lot of information. And that's because you need to know, do you need to get a permit, right? So everybody has to have a permit, not just you. It can't be speech chosen for the content or where you're at. One thing that happened multiple times is people could start walking down highways or interstates. No, that's not allowable because that goes against public safety, and public safety is more important, is how the U.S. Supreme Court has held it, and then manner as well. So, you got to be following the regular rules of not assaulting people and such. These can be regulated, again, for public safety, for the betterment of society here. But again, what you're challenging is the law. So you're not challenging your neighbor, you're challenging your law. Now, if you and your neighbor are fighting, verbally on and on and on and on, and your neighbor's like, shut up. And you're like, I've got freedom of speech. I can say whatever I want. No. You can to some degree, but you can't do defamation. You can't do hate speech, right? There are some restrictions on clear and present danger, but that's cloudy because that's been messed with a little bit. But the point is, as long as you're not doing these things, you can keep talking to your neighbor. And your neighbor's like, I don't want to listen to you. And they can go inside. There's no requirement. Okay? Qualified immunity for you if the police. Right. And then there's qualified immunity all over the place. There's they're giving it out like pardons after the Civil War. All right. Removed bigamy from a felony to an infraction. Yeah, interesting. Yeah. That's very interesting. Yeah, it's not legal. What kind of penalty gets put onto it, again, is left to the states. But is everybody finding me? Hate speech between neighbors is illegal. So usually every state's different when it comes to hate speech. Every state's different. So you're going to have to look and see what your regulations are for your state. In my particular state, if there is a harm done, if there's some kind of, it could be a minimal assault, all right? It could be a minimal assault or fear, placing someone in fear of an assault. And you're using hate speech, that's going to bump up your charge. So instead of it being just like the lowest level infraction, if you're using hate speech, it's going to bump it up to a higher misdemeanor. Or if it's at a misdemeanor level and you're using the hate speech, that'll bump it up into a felony. Hate speech is usually, well, in a lot of places, is used as a way to bump up the harm that's been done. Uh, and it's not just like, oh, hate speech, you can get charged for that. You need to have more to it than that. But some people might say, I can say hate speech all I want. It's like, that's not true. You can't say that in combination with certain things or locations and such. So you have to watch that. Yeah, it turns into a hate crime. Exactly. You got it. That's exactly right. Again, every state's different on how they deal with that. All right, so back up we go here. Amendment number 2, kind of like Mr. Orange, New York case. Got bumped to a felony. Exactly. He had a crime, a higher level crime with his false statements. So that bumped it into that felony range. Exactly right. Civil War going door to door. What's that? Oh, I don't know. I think we're like in the Civil War already. So if they're like, oh, Civil War's coming, I'm like, dude, I've been in a Civil War for like the last 6 months. All right, moving on. Amendment 2. This is like one of the most misunderstood amendments ever. All right, so come along with me here, everyone. First of all, let me say I am not a weapons expert. By any means. I'm, many of you know, I prefer a baseball bat or a whip. I'm not really a pew-pew person. But with that in mind, let's try to talk about the Second Amendment. All right, now up here we had Congress shall make no laws. So we've got laws here. Here, we're starting with a different phrase. A well-regulated militia being necessary to the security of a free state, right? So this militia piece, very important during the first, 100 years, turning into the National Guard into that area nowadays, right? The right of the people, so this is an actual right set out to keep and bear arms shall not be infringed. So every single word in the Second Amendment has been taken to the U.S. Supreme Court and smacked around. So we had the Miller case back in, I don't know, maybe it was 37. I want to say it was 37. I might be wrong. 1935 to 1937. All right. And this had to do with like the Valentine's Day massacre, if anyone remembers that, like old organized crime style, because there was one particular weapon that had been modified and used. And so the question became, can the organized crime people or can anybody go out and get this kind of weird modified weapon that was used? You probably all know what I'm talking about, right? If you've seen the gangster movies. So they're like, hey, Supreme Court, this is an arm. We want to be able to use it. The Supreme Court came in and said, first of all, no, but they set precedent here in 1935 or 37, and they said that the Second Amendment only applies to the states. Only applies to the federal government, not to the states. Now, I can take you down the road when we're talking about Lochner and going through all of the dissents and such, trying to explain the incorporation doctrine, but that's a different show. But what I will say is that in order for any amendment before the Civil War to click into place, it had to be in front of the Supreme Court and approved. So the Supreme Court said you have a Second Amendment right if you are talking about the federal government. If you're talking about a state, no, you don't. And that was good law for a really long time, until the Heller case, all right, and the McDonald case. These two cases came in with Scalia, and what was it, 2010, I think, 2008, 2010, whatever. And so Scalia's like, I think it does apply to the states. I think it's not just the federal government. Here's why, blah, blah, blah. Now the Second Amendment applies to the states. All right. So if you're like, oh, my Second Amendment right, it's so valuable, like, good for you. There's nothing wrong with that. But just know the Second Amendment didn't apply to you and your state until 2008. So if you're like, man, it was supposed to always be this way. No, before 2008, it wasn't. You had no Second Amendment right. So there you go. That's how I ripped the bandage off. Thanks, VC. Thanks, Arden. Thank you so much. I appreciate that. So yeah, that's a problem. All right. Now, the other thing too, as a quick side note before we jump back into the very exciting Third Amendment, is that imagine teaching constitutional law and waking up the next day and having the Second Amendment apply. That's a rough morning. I'm not gonna lie to you, everybody. That's a rough morning. You're like, all right, let's do this now. Because it wasn't that long ago. Oh my gosh. All right, so there you go. Second Amendment. I know everybody else gets all, whatever's about it, but there you go. Let's get into the Third Amendment. I have to say too, with this, I mean, I'm not going to say any of these amendments are bad or wrong. I'm just telling you what they say. Amendment 3, no soldier shall in the time of peace be quartered in any house without the consent of the owner. So just need consent, nor in a time of war, but in a manner to be prescribed by law. So consent to go into the homes, or the law needs to set out what the process is. Oh my gosh, Thomas, I tell you, that was a dark day. And I'm not trying to say it was a dark day because the Second Amendment now applied. But it's like, well, just tear that chapter out of your textbooks. Just tear it out, all right? That was what the problem was. And I'm like, okay, here we go. Let's put it on the final somehow. We'll do that. Oh, all right. So the thing about the Third Amendment, a lot of people don't realize is how important the Third Amendment was. There was a lot of bad shenanigans going on by the, redcoats going into the colonist homes and like taking whatever they want, including people. Like you shouldn't be able to do that, right? So the Third Amendment and this whole idea of soldiers staying in the quarters was actually raised also in the Declaration of Independence by Thomas Jefferson. That's how upset they were about it. They're like, you're doing a lot of damage to our colonies here. We don't want you staying in our homes and taking our stuff and our wives and our kids. So do you mind? So what they did, they put it in as the Third Amendment. Now, again, I'm not going to get too far into that incorporation doctrine where we look and see, has this amendment been applied through the Supreme Court under the 14th Amendment, equal protection? But the Third Amendment has only been approved through the Second Circuit at this point. Now, at any time, it could be approved through the other circuits or up to the Supreme Court at any time. And honestly, with the stuff that's going on in California and in Chicago, who knows? We may, this is exciting. This just came to me, everybody. We may see a case go all the way up to SCOTUS, where SCOTUS finally applies that Third Amendment to all the states. That could happen. So again, the Second Circuit's applied it, but, none of the other circuits have. But this could be it, because we're really, smacking around the National Guard issue right now. And so it's very possible that question could head up to the Supreme Court. That'd be really interesting, right? Right. Right. I thought an amendment was already approved. Right, Jolie. So, well, you're right. And what happened? Again, I'm not going to go too far into this. All right. But, all right. How do I do this? So SCOTUS had a case in front of it. John Marshall did. All right. So he's like the big, kahuna or whatever. Oh my gosh, the big kahuna. That's okay to say, isn't it? Oh my gosh, is that okay to say? Oh my goodness. Brian, where are you? Is that okay? All right, he's the top banana, all right? So John Marshall is the top banana. And he was like, the Bill of... Okay, it's okay. Thank you so much. I'm so sorry. That was... I got to research my phrasings, All right. So him and then others, plus others, came in and said, guess what? The Bill of Rights were only applicable to the federal government. All right, so only the federal government. Your states can do whatever they want. If your states want to restrict your speech, fine. If your states want to take all of your, pew-pews, that's fine. Anything covered by the Bill of Rights, which really only goes to the 8th Amendment, the 9th and 10th are kind of jacked up a little bit, but they ruled and they said, these are federal rights. These are not state rights. And because of that, your states can do whatever they want. So let me take you on a quick journey down the Dobbs road, right? So the Dobbs case, they're like, well, we gave it back to the states, blah, 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 blah. No, that's not right. What happens is if it's not broad enough for federal law, then the states eliminate it. So what Dobbs did was eliminated the right, because now the states could completely outlaw it. All right. A lot of people don't understand that, and that's okay. You don't really need to, do that, but, it's good knowledge to have. And I've done a lot of posts on the incorporation doctrine. I've got a couple of playlists too, if you're interested. All right, here we go, back again. Was it approved already, the amendment? So these amendments have been ratified, right? They've been ratified. The Bill of Rights that I'm referring to have to go through one more step in order to apply to the states. The Bill of Rights applied only to the federal government until they become incorporated by the U.S. Supreme Court through the 14th Amendment that was passed after the Civil War, equal protection. And then they apply to the states. All right? I know. It's weird. It's really weird. It's weird that we do that. All right, but that's kind of how it is. So what I'm talking about, we refer to as the incorporation. It has nothing to do with corporations, all right? The incorporation doctrine here. And honestly, there are still a few pieces of the Bill of Rights that haven't been incorporated yet. We've got rights in the 5th Amendment that don't apply to the states, the 7th Amendment, the 3rd Amendment's kind of like 50-50. And when I taught this originally, it used to be the 2nd Amendment, but that's no longer the case. Ouch. More work. Yes, it takes a little while for it to kind of sink in. It does. All right, moving forward here, everybody. I got to make up some time here in the air. All right, the 4th Amendment, the most litigated of all amendments in criminal court, of course. The right, so again, look at how this amendment's starting. So, no soldier shall, and a well-regulated militia versus Congress shall make no law. So here we go. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures. So they have no right to be free from reasonable searches and seizures, only unreasonable searches and seizures. Who makes that determination? The court. The court will decide if it was reasonable or unreasonable. So, yes, the government can search your stuff, can seize your stuff, can seize you, so long as it's done in a reasonable way, according to the courts. That's why when people start saying, the courts are all jacked up and the courts don't work anymore, I'm like, you're pulling out the backbone or the foundation of our entire Constitution, right? Because if you're like, well, they're all corrupt. All right, well, who determines what's unreasonable? You're going to have the president of the United States determine if every single search and seizure that's brought up in front of court is unreasonable? Like, he doesn't have time for that. He's got the golf to do. What are you talking about? Of course, the courts. But when you get into the weeds like this, people tend to forget that. And they're like, man, the courts are all bad. I'm like, well, can we just have them make the determinations at least and then give them the boot? Because, we got these questions all day, every day that they have to answer. All right, unreasonable searches and seizures shall not be violated. And no warrants, this is the warrants clause, shall issue, but upon probable cause, right? So probable cause is set out. And this comes originally from, of course, the Magna Carta when it came to the king. But one of the things to remember here, who assesses the probable cause, right? Who assesses that? It's the courts. So if you're going to say, boom, the courts don't work, well, now we have no warrants. Now, no warrants can be issued in the entire United States because the courts are corrupt, right? So, I mean, that's what I'm talking about. That can't happen. So, again, we could have problems with our courts and our judges, yes, but if you get rid of them, there's no probable cause assessment and there's no unreasonable search and seizure assessment. So your Fourth Amendment in the Constitution's gone. All right. So probable cause supported by oath or affirmation, right? So they have to swear that this information is true, and particularly describing the place to be searched and the person or things to be seized. So you just have to, there's certain rules that we have that set out how officers need to write out their requests for warrants. Go forth and spread, yes, and spread this word. Absolutely. Please, for the love of all that's holy or not holy. All right, so Fourth Amendment, that's your privacy rights. Again, it doesn't say privacy. Privacy is in what we call the penumbra, or the water blots of the Constitution. The Fourth Amendment is what was used in Roe versus Wade. Roe versus Wade said that women, right, had this freedom of not being searched and seized for medical stuff. But what Alito did was he said it's not a Fourth Amendment question of privacy. It has to do with a fundamental right out of the Ninth Amendment. And because of that, it's no longer applicable. I know, right? I'm going to try not to get too mad. All right, here's the Fifth Amendment. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia when in actual service in time of war or public danger. Now, let's pause here because that's a lot. All right. So no person shall be held to answer for a capital or otherwise infamous crime unless upon a presentment or indictment of a grand jury. This does not apply to the states. This is what I'm talking about here, all right? You do not have a right to a grand jury if you have a violation of state law, unless your own state has added this piece in to their state constitutions. All right. And again, that's because of this ridiculous incorporation doctrine. All right. So if your state has this language where no person can be held to answer, blah, 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 blahs here, then if it's not in their constitution, then it's not used. This is where we get written indictments to everyone, right? So we get written things like trial informations and such. Started years-long self-guided constitutional law. Oh, good. I'm so glad. Yeah, I'm so glad. We got to kind of, it's good to talk about it and look at all the different angles. So, and look at all the different perspectives. All right. So this is only for the feds. All right. Feds only, depending on what your state constitution says. So I'm not saying that you don't have these rights. I'm just saying you don't have them in your state unless your state wrote it. All right. Nor shall any person be subject for the same offense to be twice put in jeopardy. So that's double jeopardy that has been incorporated, or of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. That's self-incrimination, right? When you say, I take the fifth. Nor be deprived of life, liberty, or property without due process of law. So this due process of law is making a comeback, right? It's like John Travolta, where have you been? He's like, I've been here the whole time. Without due process of law here. Oh my goodness gracious. So what we're talking about when we say without due process is that there's a deprivation occurring here, all right? You can't be deprived of life, liberty, or property. without due process. Due process then comes into immigration situations. Why does the Fifth Amendment apply? It doesn't say citizen. That's why. It says person. It doesn't say citizen. If it said citizen, let's talk about it. It doesn't say citizen. It says no person, right? All right. So as long as you're a human being and you're within the confines, John, and you're within the jurisdiction of the United States, all right, you're entitled to due process. This is the due process clause that they are using in order to say we need certain minimal pieces in immigration because of that. And some are saying, well, equal protection of the law. True, that's under the 14th Amendment. The federal due process is here. So this due process does not apply to the states because of the incorporation doctrine. The due process clause in the 14th Amendment is what applies to the states, right? So we have two due process clauses. One here in the Fifth Amendment for the feds, and then one in the 14th Amendment. All right, you with me? Are you following me, everybody? Is it too much? Are my pictures too detailed? So my little scratches here. Oh, all right. Yeah, so imagine this on a big whiteboard with Post-its and red string. Oh my gosh. It's right. That's funny. Oh, good. Oh, good. I'm so glad. I'm so glad. All right. So here we go. Without due process of law, nor shall private property be taken for public use without just compensation. So this is the public domain situation here. Also the, oh my gosh, I just forgot. It just flew out of my head. When we take the stuff from the people. Goodness. I forgot. What's the other one called? The other one where they just come and take your stuff if you've been involved in a crime. Eminent domain, yes. But there's also another. Civil forfeiture. Oh my gosh, David, yes. All right, that's the forfeiture. Oh my goodness. I was going to fall out of my chair. Forfeiture. That is not how you spell it, but there you go. So the forfeiture issue, when the government takes your stuff, right? Because they're like, you used it in a crime. You got to be careful about that. So again, you have to have compensation. You've got to walk that through the system. So a lot of people use the Fifth Amendment to say that your, that law enforcement was out of line when they took all your stuff here. So that's the Fifth Amendment. All right, here we go. We're moving quick here. All right. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Yes, that's incorporated in the states by an impartial jury. And what impartial means has been, talked about for a long time, and it has to do with equal protection. So that's always a piece of it. Equal protection, right? Of a state and a district wherein the crime shall have been committed. So this is where they set jurisdiction. Why are criminal cases done in civil court? Because the Constitution says so. All right. Which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Now, I pause for a moment and I say, look, if you're in the trenches and you're like protesting and, a copper or a cube comes up to you and they're like, man, we're going to take you downtown or wherever it is they're going to take you. If you start screaming like, you need to tell me the nature and cause of the accusation that's in the Constitution, like in their face, they don't care. All right, this is something you use in court, okay? Don't be screaming in the face. They're just going to get more mad at you. You do have that right. You do. But do you have a right to have it said to you the moment the handcuffs goes on? Not necessarily. Or in the squad car, no. Or, the wagon or whatever. However you're being moved out of the area. it's going to come around again, right? And you're going to be able to sort through it. But if you just start screaming it in their face, they're just going to be like, whatever, I need you to calm down. All right. That's not legal advice. This is legal information and education. Okay. All right. And then next, to be confronted with witnesses against him. So this is where you get your subpoena power from. To have compulsory process for obtaining witnesses, again, your subpoena process, in his favor, and to have assistance of counsel for his defense. And this is court-appointed counsel here. A couple things to remember on that. That was not incorporated to the states, so the states weren't required to do that. At the federal level, you had to have a counsel. But at the state level, like even in the states where there was capital punishment, they were like, too bad, you got to defend yourself. So the people were just, defending themselves. And that, doesn't turn out well. Tea break. Thanks, Big Grandma. I forgot about my tea. I just get so excited when I'm talking about the Constitution. I can't even help myself. All right. So this didn't happen until, of course, the Gideon case. Gideon was in Florida. He took some change from the jukeboxes and ran away, and they're like, you took change, blah, blah, blah. And so they took him to court, and he was going to go to prison because it was his third change event. And he's like, dude, can I have a lawyer? And the judges are like, no. And so he's like, but I don't want to go to jail. So argued all the way up to the U.S. Supreme Court, and the Supreme Court was like, yes, you need to have counsel. Now check your state. Because even if you're allowed court-appointed counsel, you have to be super indigent, first of all. Second of all, 9 times out of 10, you still have to pay it back. You're going to get a bill. If you get convicted and you got to go, you're going to get a bill. And it'll be significantly reduced, but you're still going to have to pay. So have assistance of counsel for his defense. Doesn't say free assistance of counsel. So that's something to kind of keep in mind. All right, Seventh Amendment, which again, this one is only for the feds. And again, it's possible this could get changed. I doubt it. But in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States and according to the rules of the common law. Basically, this is saying if you've got a civil case and it's over a certain amount, then you can have a jury. That's only at the federal level. All of the states have put in... John, are you causing trouble? Oh my goodness gracious. All right, so you got to look to your states, and not all of them allow for jury trials. Do they pay after they get out of jail, or do they pay their meager jail? It's a great question. I'm not sure. I'm really not sure. I do not know of a situation where going to jail would pause your court fees and fines. Usually those get paid as you go through the process. So I don't know of any that have been withheld, but I would just imagine the road is different depending on which state you're in. Like in my state, they're gonna take out a bit each month or garnish your wages. So your 50 cents that you've made over the weekend, they're gonna take that to pay. And again, not legal advice, legal education. Now, the Seventh Amendment only for the feds. Here's the Eighth Amendment, and this is the one where we've had the most recent. I believe it was 2019. We had the most recent incorporation. I can't remember if it was Kansas or Nebraska. Oh my gosh, I think it was Nebraska. I'm going to mess it up. But anyway, that's fine. Okay. Excessive bail shall not be required. Can't be excessive. Nor excessive fines imposed. Nor cruel and unusual punishments inflicted. So under the Warren Court, capital punishment, that was cruel and unusual for 2 years. And then after that, another case came to the Supreme Court and they're like, well, never mind. We're going to just take that. What happens if you get found innocent on appeal? Do you get that back? That's a good question. I'm not sure. If your case gets dismissed everything, including the fines and court costs, should be dismissed altogether in one big chunk. But I'm not sure if you get paid back for anything. That's that's too far down the road for me. But yeah, once your case is dropped, everything's dropped. That's why all of the January 6 people, right, the thousands of January 6 people, like if you just say each one of them had $100 in court costs, now I don't do math, but they had to pay $100 in court costs. Let's just say there's 2,000 just for ease of math, right? So 2,000 times $100, right? That's how much money has been dismissed. And then that's just court costs. That's not other kinds of fees and to pay for the time that they were in jail, to pay for other things that are included, not just the fine that they got. All of that is all clumped together, and all of that money's gone now. It's all gone because they've been pardoned. All right, so this is back. Cruel and unusual punishment, that's fine. You can go, Old Sparky's up and running, that's fine. But excessive bail, right? That's a good question. Excessive bail was one of the things Mr. Orange argued about on several of his cases. Next, excessive fines. This is a case I was talking about in 2017. Oh my gosh, was it Nebraska? Oh my gosh, I just can't remember, everybody. All right, it'll come to me later. All right, so Justice Ginsburg, one of the last cases that she was on, there was a case regarding a dude who had been pulled for DRUGSs. All right. And it was like a low level. It wasn't like, a huge thing, although it was illegal. So he was caught and he was sentenced. And if he had been given a fine, his fine would have been, I'm just making up numbers here to illustrate my point. The fine would have been like $5,000. All right. So they're like, you owe $5,000 and, 6 months in jail for your issue here. And then they confiscated his brand new vehicle. Now, his brand new vehicle he had paid for with money he had gotten because his father had passed away. So the vehicle was like $45,000 vehicle. All right. So what he did was he was like, dudes, where's my vehicle? And they're like, it's ours now. And he was like, dude, that's excessive. And it went up to the U.S. Supreme Court, and Ginsburg and the rest of the court was like, you're right. It is excessive. If you put the maximum amount of penalty into the situation, it's nowhere near the value of the vehicle that the cops took. So give him back his vehicle. And then we now have this excessive fines piece incorporated to the states. All right. So before 2019, you could have been fined excessively at the state level. I'm just gonna put that out there for you, all right? It's okay not to remember exact years, thank goodness. Yeah, debtor's prison, that's a thing. Yeah, that's absolutely a thing. If you work in the system, you'll see that, and it'll break your heart. Unless you're a monster, and then you don't care. All right, Ninth Amendment, everybody, here we go. Here we go. Ninth Amendment, 10th Amendment are just these weird, I call it like potpourri or miscellaneous amendments. First one, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. All right, so this is the question here. Are certain rights available to you if they're not in the Constitution? Yes. Who decides that? The Supreme Court. All right. So this is a very important amendment because the fight is in the courts here. So enumeration in the Constitution of certain rights, meaning they set out what the rights are in the Bill of Rights, right? Right. Just because it's listed in there doesn't mean that only the listed rights are available to you. There are more rights available. All right, that's what they're saying here. There's more rights available. The Ninth Amendment is one, if anyone remembers Jack Kevorkian, or how do you want to say this? The right to unalive medically. All right, I tiptoe through the tulips here. Is one of those that's debated under the Ninth Amendment, right? None of the rights in the Constitution say anything about having that right, that specific right. So because none of them say it under the Ninth Amendment, it's like, well, it doesn't mean you don't have it. It's just we didn't write it down. All right. So, and then thank you very much, VC. Perfect. And then this is where Alito decided to take the Dobbs case. All right. He's like, well, it's not in there and not denied or disparaged. I think it has been, because he's like, the founding fathers and everybody, they didn't want to have ABs going on. So that's the Ninth Amendment. That's the Ninth Amendment. Now the 10th Amendment. And this is important because we're talking about rights here. This is saying the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, because there are powers removed from the states, especially the best examples in Article 1, where they set out Congress does this, states may not do this, and then sets out like 4 different pieces. All right. So if it's not set out to the feds or prohibited by it to the states, they're reserved to the states respectively, or to the people. So the states, again, get to have it, or to the people. Again, more of that broad umbrella. So this is about a power, and that's important. We're not talking about a right like we are in the Ninth Amendment. We're talking about a power. And if it's not set out in the Constitution, then the feds are like, you're out, and it's up to the states. And a lot of people say, well, the 10th Amendment, everything needs to go back to the states. Well, that's not true. It's a power that we're talking about when we're talking about the states. And because they're basically saying the states will pick up whatever's left after the feds go through it. All right. So the other thing too, to remember, especially with the Dobbs case, everybody, which is, don't get me started, too late, especially with Dobbs, is that the power can be delegated through Congress. So if Congress codifies a federal law, then the power is not with the state. The power is with the federal government. Why? Because the Constitution says that Congress can make laws and that the states have to follow the federal law. So the big issue, and a lot of people may not know this, probably because you're all spring chickens, luckies, but the AB debate that has been happening in the country for the last 45 years has been, since the Casey case went through, has been codifying that situation. And it never was. And so the first chance that was available, they took to overturn Roe, which was the only thing, Roe and Casey, which was the only thing making it accessible. All right. Meanwhile, a lot of people have been worried about the Obergefell case, right? So this is the marriage case. And they're, this lady also is like, man, I'm suing you because I don't want to have to pay you. So it's like, why do you keep suing if you don't want to pay? But whatever. In Obergefell, the issue wasn't whether or not you could have something. The issue was whether or not the federal law that had set up marriage, right, was constitutional or not. And it was not. It was deemed it was not constitutional by how the language. I think it was the Defense of Marriage Act, so DOMA. And then it was replaced by the Respect for Marriage Act. I don't know. That's probably not the right acronym, but it's RESPECT. Respect for Marriage Act was passed, and it essentially codified Obergefell, right? since they're using religion to make this decision, could that violate the First Amendment? If you're referring to the Dobbs case, no, not the way that Alito wrote it. He wrote it around the religion discussions. Now, John Roberts's concurrence in Dobbs, but his dissent in Obergefell, he pulled in a lot of religious stuff. But when it came to the actual language, no, religion wasn't in there enough. Right. Okay. All right. So is everybody following me on that? So Obergefell was able to get more protections quicker than Dobbs. All right. Dobbs did not have any protections on the books. Obergefell does. So if they want to take it up to the Supreme Court and say to the Supreme Court, this federal statute needs to be, rescinded or is illegal, that's a different road than taking a case to the Supreme Court like Dobbs and saying, your ruling is not okay. And Alito had ruled in the dissent in the Casey case. So he'd already taken part of Roe away. And they're saying, can you redo Roe? Roe's not appropriate. No federal backup at all for Roe. And so Alito's like, sure, yeah, let's just cut it. That's not the same as Obergefell. They're in different worlds. They're on different roads. So can they come through? Can it be overturned? Well, anything can. But I'm just saying, this isn't like, well, that's it. We're done with that. It's going to take a lot. They're going to have to overturn a federal statute that was passed and written out in a way that was very carefully done. Should apply to, I think I saw or heard a clip saying if we put in the same requirements for pew-pews in order to get a pew-pew as we did for being able to have an AB, the world might look a little different. And I think that's a good point. I think that's a really good point, right? Like you can't get one by yourself. You have to walk through a group of people telling you you're a bad person. There's a lot to that. I think it's interesting because the pew-pews are protected more than health issues for women. So that's kind of a different piece of it. Stare decisis being dismantled. It's certainly being curtailed, and it's hot. That's like the hot topic in the legal world and the constitutional law world is this turn we're making when it comes to which stare decisis is okay and which is not, because there doesn't seem to be a particular pattern. It's really just at the whims of the Supreme Court, which is, of course, extremely conservative. There, 9-month waiting period. That's right, VC. Yep. So again, I'm not trying to say I'm for or against anything in particular other than the Constitution. I'm just saying that's an interesting idea here. 20 minutes. Yeah, exactly. Exactly, Tay. I mean, that's what I'm saying, right? I mean, you can see the difference. And I think it's so fascinating here. And I'm going to go ahead and put a pause here. But I think it's fascinating to see so many people that are so misogynistic and they have no idea. They have no idea. They're like, no, that's not right. Like, really? And they just are like, whoa, like they're shocked. Like, what? That can't be true. I love, the females. Like, well, that's not what it's about. It's about, power and control over the females. What's your stance on that? Okay, yeah, you're a misogynist. All right. Enough of that. So there we go, people. I don't have time to get through all the rest of the amendments, but as a friendly reminder, let's do a quick pass over real quick. The 11th Amendment made it so that you have to get permission in order to sue a state. And this is the Chisholm case. 12th Amendment, Alexander Hamilton Amendment, changed the Electoral College. 13th Amendment here outlawed slavery except as a punishment for a crime. The 14th Amendment came back. Oh, it's your birthday tomorrow. Yay, happy birthday. The 14th Amendment, we've got equal protection. We've got disqualification from the president, although I don't think that will ever be used. We've got something about the budget ceiling has been in here too, blah, blah, blah. Due process for the states. So the 14th Amendment is huge. This is what turned the corner for the country. 15th Amendment, if you are, 14th Amendment, if you are 21 and older and a male, you can vote. If you're 21 and older and a male, it doesn't matter what your race is, you can vote under the 15th. The 16th Amendment here is income tax. The 17th Amendment here moved the dates required for Congress. So we had some issues with the lame duck stuff because the dates weren't matching up like they did in the oldies. So they moved the dates so that they're closer. So when Congress comes into session and people come in newly elected, there wasn't such a long lapse in between the elected and the old person still sitting there. And I don't mean age, all right? All right. So here, all right, so this has to do with the manufacturing, sale, or transportation of intoxicating liquors. So of course, that is our Prohibition Amendment here, right? The 18th Amendment, which was passed before the 19th Amendment, which allowed women to vote, so that's fine. All right, the 20th Amendment came in here again, and we've got terms of president and vice president ending again, so making sure to kind of clean up that problem. This is also like the what happens if something happens to the president, what's the protocol for that, but didn't really work that great. That's why we set it up again in the 25th Amendment, because this was still not that great. So 21st Amendment, of course, repealed the 18th Amendment. And so 21, 22 here puts that two-term restriction on. You can see 1947, that was because of Roosevelt. The 23rd Amendment, heavily fought for amendment. Hold on, I've missed one. Hold on, everybody, I've missed one. Just a minute. How did I miss that? Oh, okay, just a minute. Sorry. Nope. This was 32. This was 33. Which one did I miss? This was 22 here. 37. Oh, here. Is this it? This is it. No, this isn't it. I'm sorry. I got ahead of myself. I apologize, everybody. All right. I got to calm down. I got too excited. All right, so the 23rd Amendment is DC. All right, DC needed some electors. There you go. The 24th Amendment is the one I thought I had missed, and this is that there can be no poll tax for voting. All right, so the 60s passed several amendments, which shows you again what was going on in our society. 21 for 19, yeah. So under the 14th Amendment, you had to be 21 in order to vote, all right? But then we come back over here and the 26th Amendment gives us 18, all right? So 18 right here, but that wasn't until the end. So that's the 26th Amendment. All right, back up, 25th Amendment. This is the what happens when, people are kicking the bucket in office, what the order is right after Kennedy, who had passed in 63. So this is passed in 67. This is where that 21 date in the 14th Amendment was changed to 18 here. And then this one, as we talked about before, was the second article written back in 1789, ratified in 1992, having to do with congressional salaries. Whew, that was fast. That was real fast. Deported without cause. Oh, goodness gracious. Yeah, it's something out there. I would go to the ACLU. They're doing a lot of that stuff. right, get too offended by the Constitution. I don't know. I might have missed that. Happy to know I taught my constitutional lesson today. Oh, good. Good for you. We love that. We're drinking tonight. Ah! Oh, it has been a rough summer. Oh my gosh, Tay, I wish you the best. Recourse for people that have been deported without cause. Habeas corpus. It's the habeas corpus road. And it's the road that's always been available, no matter the president or situation. So habeas is what you need if you feel you've been detained wrongfully by the government. All right, that's the road you got to go down, and that's everybody's road. If you are talking about the Alien Enemies Act, that's a little different road. But if it's just in general immigration law, there's roads set out for that. We need to do public readings. Oh, absolutely, absolutely. Well, it is my favorite document. So, with that, everybody, happy Constitution Day. Oh my goodness gracious. We all remember the 4th of July, but I think sometimes we forget that we have a lot of other dates that are very important as well. Oh my gosh. All right, with that, my friends, I need to go. I'm just starting to hit my timing on here, but oh, you're so sweet. Thanks, everybody. Let me bump this up so I can make sure I can see all the comments. So we have a lot going on here. I still have the Alien Enemies Act decision to read. That's very important. I still have the Newsom case to read from California. So I have a lot of things set up still. I will be up and running from now on, hopefully. Tuesdays, I typically am over on the tube. And I'm going to try to keep that schedule. And as of now, I'm already moving about 30 to 45% of my time each day now is spent on the tube. So happy to be over there doing some interesting things. I do want to go through the charges for the fella in the Utah. I will be doing that over on the YouTube, all right? I will not be able to read that over here. So I do have all of that printed out so we can look at that and see what's going on with that. I know a lot of people have questions. Yes, AC, I know. Bummer. A lot of bummers going on, but when it comes to First Amendment and those kinds of things, they take just a little bit of time to settle down, and then you can see what exactly has happened. Good night, Kaya. Have a wonderful evening, everybody. That's not for a true story, right? When you're going to do that case on CK. Yes, I will make an announcement or put it in my little bubble, over here. So I'm not sure exactly what's going to happen here on the talk, but John, oh my gosh, nighty-night. Thanks, John. They do. They match the papers. Anyway, but no matter what, I'll be over on the tube. Well, take care, everybody. I got to run. Have a great night. Happy Constitution Day, everybody.